This is Muralidharan. I am going to talk about today on the subject of immunity to registered trade union under the section 17 and 18 of the Trade Union Act. What about the name of called the immunity? The immunity means there are some exceptions to the union office bearers when they are occupying the position of office bearer in the trade union because they have to face the so many challenges from the management and also from the point of view of police and the other penalizing authorities. So, in the Trade Union Act 1926 itself has given some of the exceptions when the either from the government or from the employer there are some exceptions, that is immunity powers has been given to the office bearer of the trade union. First, we are going to see about the section 17 of Trade Union Act, which talks about criminal proceedings against them under section 120B of uh, Indian Penal Code. And another section 18, this talks about the civil wrong. When they does some civil wrong, how it will be dealt. Both the definitions are given under the Trade Union Act. So I am not going to go inside of the what is in the definitions, what it talks about the 17 and 18, that or not. But I am going to analyze how this 17 and 18 will impact the employer when the time of the problem, when the trade union is having the registered trade union may have the demonstration against the employer when the time of strike or when the time of pen down strike or go slow strike or when the time of damaging the property of the company, or they may indulge not by the union members but the office bearer themselves can do all these things. We have seen in many of the recent incidences in India. So, how these things are viewed by the judicial authority, we are going to see about those things because nowadays many of them are into social media. If he does something in the common public things and all, then automatically it will be casting into the so many social media like LinkedIn, Facebook, and YouTube and other thing. So immediately it will be catch up in the social media, and subsequent to that, the gatherings will be in front of the company. How it will be dealt by the judiciary authority? To be frank with you, when I read the so many case laws under this section 17 and 18 of Trade Union Act, the employer power is very less when some activity, that is modified activity, has done by the trade union office bearers, that is registered trade union office bearers, and the judiciary authority is waiting for whether something has happened, then only they will take up the matter for the review. That is, the prima facie of the case can be registered against them only if something gets wrong. Otherwise, if they are doing some peaceful demonstrations, the either from the police authority or from the judiciary authority, say for example, if we are asking for the interim injunction order from the court for the demonstration in front of the company. In so many instances, the the court has not, a civil court has not given the interim injunction because this is comes under the trade dispute, not as a industrial dispute. When they are road robo, caro, or pen down strike or slow down strike, all these things. We will see in the forthcoming slide about all these things. What section 120A of IPC, it talks about when two or more persons agreed to do or caused to be done some illegal act or act which is not illegal by illegal means, such agreement is designated a criminal conspiracy. See here, section 17 talks about If two or more people assembly, say for example, assembly in front of the company, say for example, the office bearer of the registered trade union, and they are making sloganeering, and uh, they are stopping they are standing in front of the gate and stopping the people. The trespassers has been stopped, and this is observed by the CCTV. Nowadays, the media, the IT technology is very empowered in India. Even though in these cases, the judiciary has not accepted in many of the cases, provided it should be the trade dispute, not an industrial dispute. This is very clearly said in the so many judgments. And why I am bringing this 120A IPC at here means under section 15 of the Trade Union Act, what are all the things will come if they indulges any misconduct or mischief in that section, then this section will attract. Otherwise, in any of the act of the office bearer of the registered trade union, you cannot take any action against them unless otherwise it has some paralysis of the community at large. Otherwise, the police will not register the case, even register the case, I would say. And this is available only to the office bearer of the trade union. This is advantage for the employers. If the office bearer does something, you can't do, but the office bearers normally do all these things. The rest of the employees will be behind the screen. We have seen many things, and there should be some agreement between them, and there is some common objectives should be them among them. Then only you can take action. The act should meet the section 15 of the act. Otherwise, you cannot take the action. What is section 15? We will see in the later slide. The act should not commit an offense. So, in this section, the office bearer of the trade union, they should indulge under section 15 of the Trade Union Act. Otherwise, you cannot take the action under the Trade Dispute of Trade Union Act. But we can take the action against the Industrial Dispute Act under the Industrial Dispute Act of under the sections read in the Industrial Dispute Act. But here under the Trade Union Act, you cannot take the things in the employer cannot take any action against them. Immunity, geo-borrowing community interest, and the dispute connected with the trade dispute connected to the section 2G of the Trade Union Act and not in aligned with the ID Act. Under section under 17 and 18, you cannot take action because this section clearly talks about the trade dispute. This is not talk about the industrial dispute. The workman under the Trade Union Act covers all, but there is a difference between the definition when we compare under the ID Act. ID Act workman definition is scope is very limited. They won't consider many of the people under the workman category, but under the section 2G of the Trade Union Act, it covers all the people. There are these are all some of the glimpses in the Trade Union Act. Negativity for the employee. And section 15, we can take the criminal action against the police can file the case against them under section 120. They are paying salaries, allowances to the trade union office bearers, prosecuting or defending legal proceedings, conducting trade dispute, and providing allowance to their members. All these comes under the general fund of the section 15 of Trade Union Act. If any flaw of the among the trade union office bearers, we can take the file the case against the section 120B. Otherwise, we cannot take the action under section 17 and 18 of the Trade Union Act against the registered trade union office bearers. And What is called the trade dispute? I already mentioned on many of the times about the trade dispute or the other thing. Trade dispute means the dispute between the workman and the employer, or the workman and the workman, or the employer and the employer. However, it should be connected with the employment or non-employment and the condition of labor or any person. Here, the workman means all the persons employed in the trade or industry, whether or not in the employment of the employer with whom the trade dispute arises. So, Section 2G of the Trade Union Act very clearly said about the trade dispute. Here, when we compare the industrial dispute and the trade dispute is covering all the employees, if you see the definition. But industrial dispute scope is very limited. All the people cannot file the case against the employer. And the employer also cannot register the complaint against the any employee under the Trade Dispute Act, Trade Union Act, under the definition of trade dispute. Under Section 17 of the Act instituting the dispute, arbitration normally fails because this covers under the larger extent than ID Act. And but as per the last paragraph of the under Section 17, the agreement with more of two persons with the intention to do cause which result on offence surely unactionable under or criminal one. Here, if two or more people connected with the dispute and making any offence, then they will be captured under the Trade Union Act. And we can file a case and the court will decide about their punishment and all. That will come under the criminal law. But the things are not covered under Section 15 of the Trade Union Act. We cannot take action under the Section 17. The withdrawal of labor, any action will comes under the civil rank and actionable under Section 43 of the IPC. Larger concession drops here action. Here, if some road rogo or kero or pen down streak or hunger strike during the time of office hours, I would say during the time of office hours, if they call all the people from the factory and they can also call other industry people also, and they are making some sloganeering or something like that, and they want to get the attention of the employer and withdrawing the labor in any action, and this will comes under the civil rank and actionable under the Section 43. Unless otherwise, it should be the comes under the offence, actually criminal offence they would have done, or otherwise mere withdrawal of the labor from the industry won't, we cannot take action against the trade union office bearers. Very clear under the Section 43 of the IPC also. And to do or cause to do an act, the withdrawal of the labor on economic coercion, and this will comes under the Section 120B of the IPC, but loss or damage cannot be covered under the civil suit. Here again, Section 7, if you see the Section 18 of the Trade Union Act, withdrawal of the labor and the running of the factory itself is the questionable one. The factory won't run without people and all. And the employer on many occasions, when they faced the such a type of industrial interest, they made the complaint before the police station under Section 120B, and they made the complaint under the they filed the case against the registered trade union for the loss or damage to the property, but the institution of the civil suits will not sustain because they have the immunity under Section 18 also. So recovery of the property damaged property is very less, very less. When we see the case laws also, the Indian Bank versus Federation of the Indian Bank Employees Union, the banks prayed for the interim injunction within 50 meters of the regional office because the employees went on strike and they were demonstrating against the management, and the management, Indian Bank, has asked the court to give the instruction not to do the demonstration within 50 meters, but the court denied to give the instruction and the Madras High Court stated that they cannot deprive the legal right of, that is statutory right given to the trade union people. That is what the judgment given in the Indian Bank versus Federation of the Indian Bank Employees Union. And when we see other case also, Indian Newspaper Private Limited versus T.M. Nagarajan, the Delhi High Court denied to grant the relief to the union under Section 18 of the Trade Union after scrutinizing the documents and blind with enough proof of the damaging their property. Here, in this case, the Indian Newspaper Private Limited has filed the complaint against the trade union, registered trade union, and they adduced with so many evidences when they are making the case. The Delhi High Court has seen the prima facie of the case itself, and they registered the case against the trade union under the Indian Newspaper Private Limited versus T.M. Nagarajan. Here, this is the only case which I have seen when we file the case against the trade union, registered trade union. We should be so cautious. The evidences will speak under section 17 and 18. So we must be very careful when we are recording the evidences and all. When we see the Ahmedabad Textile Research Association versus Adira Employees Union, the court denied to give the injunction to the company for peaceful demonstration. So in this case also, the immunity power has been stressed. So the injunction order has not been provided to the Ahmedabad Textile Research Association case, and the union has got the immunity under this case. And Rohtang Industry Staff Union versus State of Bihar. In this case, the case, the arbitrator given the award to claim from the union for the damage due to the strike. The union has called for the strike and they damaged the property. The company has filed the petition before the arbitrator. Arbitrator asked the union to give back the whatever be the damages caused to the company, and the union taken up the matter to the High Court, Patna High Court, I think, and they declined by stating that this will comes under the section 24 of the ID Act, and this is not the civil rank against the Trade Union Act. Very clear, and this is a very famous case. So they asked the union, asked the management to file the case under section 24. This is not the trade dispute. This is the industrial dispute. This is not the trade dispute. They very clearly said under this case. On appeal, the company made on appeal before the Supreme Court, and they also affirmed that civil wrong cannot be instituted against them since there is no dispute between the employment or non-employment issued connected with this petition. So, in this case, they clearly said that this is not the trade dispute. This is the industrial dispute. Under section 24, you can take up this matter to the respective authority, not from the relief from the civil court. So, this is not the civil wrong. They said under section 18 has been quenched by the union. This is very famous case. And another case, this is also a very famous case under JE Engineering versus Staff, Calcutta. This was happened in the Calcutta High Court. The question has been made: Kero and strike under section 17 and 18 allowed or not? So, when the people made on strike and Kero has been conducted, whether that has been allowed or not, questioned by the company, and there is J Engineering. The court, Calcutta High Court, very clearly said that peaceful demonstration inside or outside without violence is allowed. If the demonstration has been happened without any violence, that is allowed under the act. So we cannot take any action, or we cannot give some direction to the trade union and ask them to stay away, and there is no availability of injunction, interim injunction order, something like that. That is very clear under the J Engineering case. And criminal trespass or indulge criminal force or criminal mischief or assault or the property damage, the exemption will be withdrawn. So here under section 1718 will be withdrawn when they indulge any criminal force or mischief or assault or property damage. At that time they are ready to give the relief. Till such time, if anything goes wrong, if the mob has fired the company, whether we have to wait the loss made to the how the right given to under the constitution under 19 section 19(1) G for the employee. Here the right so, under the Trade Union Act 1926, the union can do anything under the judiciary the other police authority will see anything has happened, they will come and register the case, or otherwise they will wait and see. That is very clear in the recent judicial pronouncement under the section 17 and 18 of the Trade Union Act. And in the RBI case also, the same Calcutta High Court reiterated the section 18 will apply when the trade dispute will be on the lawful means. In the Madras High Court, Sri Ramavilas Service versus Simpson Group of Employees, there also they clearly said that the, the court will not intervene in this matter when the demonstration has happened very in a peaceful manner. Then the High Court won't intervene when this as a legitimate right. So when they are fighting for their legitimate right, the either by the either under the various section under the IPC or in the civil damage, civil wrong done by the union, and it is reviewed by the employer and filed the case against the union, registered trade union. As of now, there is no relief for the employer. When I read so many judgments under this section 17 and 18 of the Trade Union Act. So, in the nutshell, what I am saying, this immunity is available only to the registered union office bearer, registered trade union office bearer. And number two, if they made any civil wrong or criminal wrong, the footages or the CCTV footages are from the recent some of the AI techniques and all. We have to take the evidences and it has to be adduced before the court, or otherwise you cannot get the things. Number three, something happened in the industry, trade, business, or otherwise, either the support from the either from the police or the civil court, you cannot get the relief. This means you cannot get the interim injunction, apply for the shout for the interim injunction or something like that. They can be get it from them only if the thing has got worsened. Till such time, if your supplies to your customer, or if your consumer is badly affected because of this, even before the Consumer Protection Act, you cannot get the relief under this section 79 and 18. A major relief has been given under this section under the Trade Union Act. And also, if the employer has lost many things by the way of damages, or by the way of less protection, or by the way of very poor quality product produced during the peaceful demonstration, even though we cannot get the relief from the judicial authority, either from the judicial authority or from the whoever taken care of law and order. So, under this section, under this Trade Union Act, the employer cannot get the relief. This is what I want to say. Available to the registered trade union. Kindly register to Murli HR my YouTube and awaiting for your replies in comments in my YouTube. And thank you. And I will meet you once again with the another important subject. Thank you.